Thank you. Thanks, Eduardo. Thank you. Sorry for the technical issues again.
But I still don't see it, Christine. I don't know if I'm having the same problem. I wonder.
Oh,
okay,
yeah.
now it's showing up. Perfect. All right.
Oh, okay. So now everyone can see it. Okay. I'm very sorry.
Keep in mind, you lost 3 minutes, and I think we can't really get them back. So try to skip slides which aren't so relevant for you. Okay.
Okay. Okay. Thank you. Okay. So I will skip a bit the introduction on the topic. Let me just say that I'm not a legal scholar, I'm a political science scholar, so I came at this from a bit of a different perspective because there are more qualified people than me to analyze the data protection regimes. Where I came in through for this topic was what was the motivation in a way for the UK and the EU to maintain a working relationship in terms of information sharing. And what I have tried to conclude, even though the paper is still at a draft stage, but I feel like I've made the conclusions for myself that the motivation was to continue to have a continued cooperation in law enforcement and judiciary, and to continue the information flow between the two parties, so the UK on one side and EU member states on the other. So this has been the main motivation, which has sometimes served perhaps as a bit of a trade-off for the high standards of data protection regimes that the EU specifically has tried to introduce. And there are some gaps that will need to be filled in terms of where the UK could catch up a bit to the EU regime. And unfortunately, it seems like the EU might have traded off a bit of that for continued law enforcement cooperation relationship. So the UK has traditionally been a bit of a reluctant partner in criminal justice. However, it has contributed to a lot of instruments, including PNR, Europol, mutual legal assistance, etc. And as such, it was important for it to have a say and to be an agenda setter in this topic, which now it won't be able to have as much. However, both the EU and the UK have tried to make sure that the agreements are close enough, as close as possible to the original agreements under the EU membership that the UK had. And the TCA has come up with some unprecedented, for this domain, bespoke arrangements that would likely not have been offered to other third countries or partner countries with the EU. So these are that you see on the slide are the 8 main topic areas of cooperation. As time is running, I'll try to just briefly go over them. These are the ones that were considered priority areas for both the EU and the UK. And these are the ones where truly bespoke arrangements have been made, and they should ensure continued smooth cooperation on law enforcement and judiciary investigation procedures. However, the question then remains, is it a trade-off to the quality of data protection, and how it might affect it in the future? Because according to my at least overview, it won't be possible to judge on that until some operational work has gone under these arrangements, so we can actually see how this agreement lives within the operational work. So let me just go briefly through each of those 8 points. So the first point is on the so-called Proom agreement. So this is the exchange in which was in Proom in real time of DNA, fingerprints, and vehicles registration data. This is done also in small-scale crime. So police puts in this information in a database, which has been quite useful in solving both small-scale and large crime across border, of course. So the TCA allows this cooperation to continue. However, this exchange won't occur in real time. It will occur through national contact points that the UK and the EU will set up for each other. So the exchange could still occur, but this lack of real-time sharing might impact the speed of exchange of information, the speed of resolving a case. Perhaps some leads might be missed, etc. However, there are some trade-offs here reported by data protection observers and watchdogs like State Watch, that since the UK still has to finish some adaptations to the new mechanisms that are required of it. An ex-ante evaluation, a pilot run on vehicle data were required by the UK. However, the EU gave provisional access to the UK to the EU Proom system, despite not having accomplished that yet, which should be accomplished this year as expected. However, the UK, in the meantime, while not having actually proven that it can exchange data in this field, it has already exchanged with the EU. And similarly, in the PNR, here it's a bit easier because PNR was originally a UK system. It is meant for sharing data on flights within the EU, and in this case, it would be between the UK and the EU. So the UK already has its own system on that, so the exchange will be between the two systems. However, again, through national contact points. However, the UK will have to introduce mechanisms to delete data after passengers leave the UK, excuse me, as well as it is allowed retention for up to 5 years, after which data will also have to be deleted. So until it sets this up, the EU has again allowed exchange to continue, which has been critiqued by some data protection watchdogs, as I mentioned, because even though the EU adequacy decision, as was discussed yesterday, is already in place, there's still some questions that remain about the UK's use of data, especially personal data. Operational information is not defined very concretely in the TCA. How I have understood it or treated it in my paper is to mean mainly the data that was in the Schengen information system, that is law enforcement data, mainly about larger crimes and terrorism, cross-border. So especially also when the suspect is being followed, these exchanges occur. So this also by now includes some DNA, etc., vehicle data. So it overlaps a little bit with Proom. And it's the most used law enforcement system from the EU's ones, and it's one of the largest losses for the UK. However, the TCA sets stipulates some conditions in place to make sure that this exchange continues. Interpol will be the de facto replacement for Schengen information system for the moment for this kind of information exchange. Although it comes with its own drawbacks, it's much slower and some functionalities don't exist. Also, member states, importantly, will have to duplicate their data across both databases, which they are not required to. They will just be expected out of goodwill to do that. So there might be some gaps in information flow there because some member state perhaps hasn't managed to duplicate the data in both information systems. And I also would like to mention that according to State Watch, the UK is setting up a new platform. It's called an International Law Enforcement Alert Platform, or ILEAP, which is expected to be functional by 2025. And it seems to be the response of the UK to the loss of SIS and to the criticism of Interpol. So it's aiming to set up its own system, which it can use with the EU partners. Cooperation with Europol is the other very important feature for the UK that the UK was trying to to gain as much access to Europol's tools as possible. Functions similarly with Europol and Eurojust, and in the interest of time, I'll bundle them together. So Europol and Eurojust will respectively post liaison officers and liaison magistrates across each other. So Europol will have one or two of the UK, and the UK will have one or two in their respective authorities. Exchange of information will be via national contact points, but also in terms of Europol, the UK will still have access to the Siena highly secure network of exchange. This is where confidential data is shared. So let's say law enforcement with intelligence quality. So transfer of personal data is limited, and data will not be allowed to be transferred by the UK to third countries, and the purpose of limitation will apply. I will skip Eurojust to go to the other very important for the UK, especially in terms of its relationship with Ireland. Functionality, the surrender procedure, or formally the European arrest warrant. A new procedure applies here, which in the absence of the EAW, the UK and the EU would have had to go to the 1957 Council of Europe Convention, which would be highly dysfunctional in our current days, because it took 4 to 5 times longer to surrender nationals and to extradite suspects, even when the suspect and the country agreed, just because the procedures were so bulky and bureaucratic. So the new procedure comes sort of in between the old one and the new one. And two fundamental differences apply. Even the time frames are more or less the same, which is quite an achievement. Two fundamental differences apply. The so-called national exception, which is that either the UK or a member state can declare ex ante that it, in a way, does not trust the legal system of the other state, so it refuses to extradite its nationals. And in that case, it needs to consider domestic proceedings against its national. In this case, this needs to be done ex ante, as I said, and excuse me, and it can be reciprocal. So already 12 EU member states have declared that they will use this exception. The other exception is, or the other difference is the so-called political offense exception. It means that the request cannot be refused on grounds of that the offense might be political, except when it's in the case of terrorist offense. However, this can also be derogated from if member states ex ante declare that. So 12 member states also have already notified of using this exception. Still, some fundamental rights are, at least in the text of the TCA, guaranteed with this, such as legal and interpretation assistance, and proportionality and necessity in terms of the scale of the crime and the interest of the victims. So this is, at least in principle, still applies. Double criminality is also required, i.e. that the crime is considered a crime in both jurisdictions, the requested and the requesting. And this can also be waived via way of notification, which also already 15 EU member states have done. So you can already see how this is grounds for some bureaucratic issues in the future in the application of this instrument, which it was one of the most useful ones for the UK until Brexit. So it remains to be seen. Mutual assistance, or as it is called now, mutual legal assistance, is a combination of 3 Council of Europe conventions and the former European Investigation Order, which was also considered worthy of keeping. There are certain conditions on this. Again, double criminality applies. So if the person is already convicted in one or prosecuted in another member state, he would not be convicted or prosecuted in the second member state. The punishment has to be proportional between the two countries. So the crime has to be similarly punished across the two jurisdictions. And there are grounds where it cannot be refused. The deadlines are similar. For 45 days after the receipt of a request, a decision must be made, and it must be executed within 90 days, which perhaps might be unrealistic considering the third country status of the UK now.
Just to give you a heads up, you have only 2 minutes.
Okay, thank you. I'm just on the last of the 8 elements, and then I'll wrap it up. So another very valued judicial instrument for the UK was the database on exchange of criminal records, which will continue without the database. So the UK will have to set up its own software, which it will be responsible for to be connected to the database. It will be called EUCRIS for UK. And the deadlines are similar. So within 20 days, in the EU system, the deadline is 10 work days to inform each other of convictions of each other's nationals. And within the new arrangement, it will be 20 days. So it's quite similar. And then the exchange will happen via, again, the encrypted infrastructure. The UK will be responsible to set up all of this. Importantly, by now, the UK has also the EUCRIS TCN for third country nationals residing within the EU. The UK will not have that and will not be able to access this information, which will affect for sure law enforcement exchange. Purpose limitation applies again, and still there is some concerns reported by data protection watchdogs that this might infringe the use of data somehow. There are other areas of justice, home affairs cooperation that I will not go into. They are mentioned in passing also in the TCA. Those are the anti-money laundering and terrorist financing arrangements, as well as freezing and confiscation orders.
I'm sorry, you're really running over time. We're already 5 minutes beyond the 15, so you need to wrap up. Okay. Just last thing to say is that since the UK did not want ECJ jurisdiction, there's a bespoke dispute settlement for these clauses. And just to wrap up, I will not go through all the points as I've already mentioned them. It's important for me that due to the heightened terrorist threats in the last 8 years or so, the UK did see some value in the EU instruments and tried to retain as much access to them and tried to fight for a bespoke arrangement. However, it's clear that the EU also wanted that and was pursuing that. So the goodwill was definitely clear in these very bespoke, very deep arrangements with a lot of exceptions, just so that the apparatus is still functional. However, how that impacts data protection standards and data exchange standards is still yet to be found, and this will come from the operational work and how the agreement actually is applied in operational work.